Welcome back, everyone, to another episode of Circle City Conversations. I am here today with my dear friend, Ned Mulligan, who I've known for many years. Ned, thank you so much for being here.
Yeah, thanks for having me. I'm excited about this.
So, Ned, this is your first podcast, right?
It is.
Yeah, but you're a trial lawyer. It's like you're like an old pro, right?
And I like to hear myself talk, so there's that.
That was I got to. Have you ever officiated a wedding?
I have,
yeah.
yeah.
That was my lawyer joke while I was officiating. You know, about the lawyers loving to hear the sound of their own voice. Or no, I think the joke was, if there's anything a lawyer likes more than money, it's the sound of their own voice.
I think that's fair.
And that one hit a little
And
bit.
helping people,
Yeah.
right?
Yeah.
Yeah.
Yeah, right.
Helping people.
Well, but people don't know that. They just assume we're a bunch of, money hungry trial robots, right?
Yeah. No, absolutely. Yep. I officiated my brother's wedding, and it was more nerve-wracking than I thought it would be. But
Really?
Yeah.
Did you have to do the best man speech? And
well, so that was the part I didn't like about it. I was like, wait, you're telling me I'm not your best man? I'm officiant? Like, I think I'd rather be the best man. So my ego is sort of like, fighting with itself.
right.
But I settled with the officiant. That was okay.
Right.
I did roast him pretty hard after that.
Nice.
Yeah.
Well, you should. I mean, that's what brothers are for, right? So there's that. All right. Now we just learned a little bit about you, but Ned, you haven't been on the show before. We may have some listeners that haven't had the pleasure of meeting you or don't know you. So why don't you tell us a little bit about yourself?
Yeah. So I've been a lawyer for 15 years. I went to IU Maurer School of Law in Bloomington. Love that town and love that school, and very proud of, especially now, having had them win the national championship. I am a transplant. I grew up in New Hampshire originally, which maybe explains why I talk so fast. It's just East Coast. Can't fully unbake that. But I've been in Indiana for the last 20 years, and despite a couple times trying to leave, have been unable to, and this has now become my permanent home and probably the place I identify as my home more than anywhere else. Since law school, I've been a lawyer at Cohen & Malad, one and only job. Plaintiff's firm.
Okay.
Yep. And plaintiff's firm downtown here, probably 20, 25 lawyers, a bunch of different practice groups. I've been mostly focused on suing prescription drug and pharmaceutical companies.
Mhm.
And a lot of those claims are based on like a failure to warn theory.
Yep.
So I represent individuals who've either taken a prescription drug or had a medical device either used after surgery or implanted into their body for a long period of time that then failed or caused some injury. That's more or less what I've done for the last 15 years. I have done some medical malpractice as well, some personal injury, other things like that. But more personally, I live in Carmel. I've got beautiful wife Dina and 2 little kids. They keep me busy and tired, and but they they make it all worthwhile. So,
And you are an avid DIYer. You try to do things on your own.
I am, and I never used to like to do this stuff. And then my brother, who's an executive at Amazon, decided that instead of paying someone to redo his kitchen, he was going to do it himself. And I just didn't quite understand that. And then I watched him do it, and I was like, wow. And he made all the harder choices that he could have made. Sort of big tile. He chose tiny tile, and it came out great. And I was like, man, if he can do that,
Yeah.
I can do that, right? And that's sort of been my mentality, I think, throughout my life. And I've learned that, I think he's a little bit less of a perfectionist than I am. That tends to get in the way of me picking up new things. But my latest project is I decided I wanted a windowsill on a window in our front bedroom, our front room. And I was like, I'm going to try to do this windowsill myself. So I pulled the trim off. And of course, I look at all the rough opening underneath. I have no clue where I'm going to put this windowsill. And so, I'm asking ChatGPT literally every single question. What do I do next? Sending it pictures and things like that. But so a little DIY. I've gotten better, but I'm going to stick with the day job.
Yeah, right. Yeah, me too, man. It's nice to do this stuff. You feel so great and accomplished when you look at your project and whatever it was you were able to get done, and then you were like, man, if I build hours for this would be a lot of money.
It would probably be a $3,000 or $4,000 windowsill.
Yeah.
And it doesn't look nearly as good as it should for that price. Yeah, that's pretty true.
Yeah. So you mentioned that you've been at Cohen & Malad your entire career.
Yeah.
Okay. So tell me a little bit about kind of the beginning of your career there. What was that like?
Yeah, so it was really interesting. I went to Bloomington. I did pretty well there, and I think the sort of formula at that point in time was if you were where I was in the pack, you'd get a job at a big defense firm in a big city, and that was just kind of like nobody ever told me, hey, you don't have to do that, or that's
Right.
not necessarily the thing you should do. Have you thought about plaintiff-side? No one ever said that to me, and I was just like, well, I was a golf pro before. I had made $27,000 a year. I knew that wasn't going to be the answer. And so I was like, well, I'm just going to do as good as I can, go through law school, get a job at a big firm, and then I'll figure that out at that point if I don't like that. And then the recession hit in '08. And
Yeah.
I had a bunch of interviews where they were flying me to Chicago and putting me in hotels. And that was the end of that. Like that was literally my second year interview year. And so went through law school, and I had a couple summer internships, didn't have a job lined up after school despite having good grades and all that. And Cohen and Mallad just popped up on in-campus interviews in June when I was studying for the bar. I interviewed, and they hired me. And I was like, they were like, you're going to be a pain pump associate. And I was like, I have no idea what that means. I'm not even sure I was confident enough to ask them at the time.
Yeah.
But I said, hey, just pay. And are you going to teach me stuff? And they said, yes. And so that's kind of how I got into it. And I learned quickly that pain pump is a medical device.
Correct.
And we had a number of, we had a couple hundred of those cases that were litigated all over the country, and they needed manpower and briefing. And I think those first couple of years, I probably worked on average about 85, 90 hours a week. And that was a little bit of a rude awakening. Not something I want to do again, but I learned a lot very quickly. And I think learned, they were fighting for people that had something really bad happen to them, and why that's meaningful.
Yeah.
So,
and you need that time. I was talking to someone the other day about this, that 85 hours a week, because you need that time, because as a young lawyer, as a new lawyer, you don't know what you're doing. Yeah. And that time is essential to helping you get ready, just to be a better lawyer for your clients. So you started with mass torts.
Yep.
And
that's all I did.
That's all you did. We haven't had anyone on the show yet talking about mass torts. It's a different process. It's a different procedure. Why don't you go ahead and describe that a little bit to our listeners?
Yeah. So I think a lot of people confuse mass torts with class actions.
Yes.
And, they're like, I don't want to be in this class action, or is this a class action? And, class action usually involves a scenario where there's a wrongdoer and there's a lot of people that get injured, but usually the injuries are financial, right? And, or maybe not financial, but not like a physical injury.
Right.
When you have a physical injury, and the reason for that is because you can have one plaintiff who pursues the case on behalf of all, and everybody else's damages are sort of easily ascertainable.
Okay.
In a mass tort case, you've actually got to have every person injured has to be a plaintiff, has to be separately retained, and that's because they all have unique damages. So
correct.
If you had a medical device put in you, like a hip implant, and I did, and it fails in you and it fails in me, it's going to be different, right? It's going to be a different amount of time. We're the same age, but let's say, you were 30 years older, your damages would be different than mine, things like that. So that's why you have to have the individual plaintiffs, but they do end up getting a lot of times consolidated in one court. So in a federal court, in an MDL, sometimes state court consolidations too, where for pretrial purposes, the discovery is done collectively on behalf of everyone. So I liken it to a lot of patients, or I guess there are patients, but clients as it's kind of like a cruise ship. You get on the cruise ship. Everyone's got to get on the cruise ship, unlike a class action where only one person has to. Everyone's got to get on. The problem is you can't get off until everybody else gets to get off. And so that, it doesn't progress it. There's there's not individualization in the terms of like when the case resolves, which can, unfortunately, I think, we do this consolidation to make discovery against the defendant more efficient.
Yeah.
But it can also cause delays in resolving the case. And it creates some weird leverage points as well in terms of resolution and things like that.
What do you mean by weird leverage points?
So sometimes you can have too many people with
Yeah.
claims, and the defendant, the amount of money it would take them to resolve the case is just so big that they're like, we're not going to
We
do
don't
that.
care. Yeah.
And, an example of that would be, let's say, in the talcum powder litigation, there's
Yeah.
50 to 75,000 claimants, and Johnson & Johnson's like, well, how many of these are you realistically going to be able to take to trial every year? And the answer is like 4 to 5. They're like, why would we pay these people?
Right.
Let's just drag this out for decades. And that's what they've done. And so that, if they were in individual courts on individual schedules around the country, it would be a lot different. There'd be way more pressure on a big defendant like that. And so while this consolidation is intended to create more efficiencies, it creates some sort of, unfortunate side effects, I guess I'd say, in terms of getting the cases resolved.
And going back to your point about discovery, these companies that you're dealing with, when you're trying to get information from them, do you have to keep going back to the well multiple times to get the information that you need?
Sometimes it could. I think it kind of depends on who the defendant is, and who the lawyers are, and also whether they think they have something to hide or not.
Okay.
I've had some defendants just freely give me stuff, and then others just very obstructionist. So it kind of depends. And the problem with the consolidation is you end up having a plaintiff steering committee, which is just like handful of lawyers that take the lead. But sometimes there's too many lawyers in the room. There's too much consulting happening. There's too much there's too many steps baked in. You can't just send out interrogatories right after you file your complaint. You've got to go through this whole thing, this morass that I think really has sort of turned into a big delay tactic for the defendant.
Yeah.
So
you started your practice. You spent a lot of time in the office. Is that fair?
Yeah.
Yeah. So
the adage at Cohen & Blatt when I first started there was, if you're not here, you're not working.
Yeah.
And so it didn't matter where you were or what you were doing when you weren't there. And I back in 2010, I think that was probably pretty consistent anywhere. We've obviously changed.
Yes.
A much more flexible approach now. And obviously I'm,
Yeah.
So I don't mean that as a sort of criticism.
No, I mean, I had the same thing. I mean, what did Irwin say that? Is that an Irwin? I love Irwin.
I played
he's
the
like,
fifth.
yeah.
I love the guy though.
But Irwin, he's like Bill Hurst, my partner. And it was the same. I heard the same thing from him. If you're not here, you're not working, know? Yeah. So, no, and I get it. And frankly, you have small kids. I have small kids. It's hard for me to get things done at home.
Yeah.
With the kids.
I think if I had small kids then, I would have struggled, because I think, my goal then was to be the last one out of the office, because it was very important to me to set the right tone. I wanted people to think highly of me. Yeah. I wanted people to know that I was reliable and that I was there for the right reasons. And so there was occasionally times where I would, go walk around the office and see if anybody was still there.
Right.
Maybe I shouldn't admit that, but I think
that's all right.
That's the way things were then, maybe less so now.
Right. Yeah.
Yeah.
So you spent a lot of time in the office at first. Eventually you worked your way into a courtroom, trying cases, litigating cases. What do you think separates those lawyers who try cases in the courtroom from those who avoid the courtroom?
That's a really good question. So the downside of mass torts, I think, at least in the beginning, was there's not a lot of trials.
Yeah.
And when there are trials, it's like Mark Lanier is doing the trial, right? So there's
there's
not a lot of room to get into
weeks long trial.
Yeah, like 8 weeks long.
Yeah.
And I don't know why anybody would ever want to sit through an 8-week trial or even try one of those. But for me, it was, I realized that the way I was going to get trial experience was by doing some different kinds of cases on the side. And so I started doing medical malpractice cases. And, I'll be honest with you, I've always wanted to be a trial. My dad was a trial lawyer. He did 125 jury trials.
Oh, wow.
In New Hampshire. I know they were 1 or 2 day trials, but, big
doesn't matter.
trial
Still
experience.
trial.
And I've always idolized him to a degree. And so I did this, I got into med mal. But I was terrified. I mean, I think anyone who tells you they aren't terrified before their first trial is not being honest. And
right.
I think you have to want it enough to put the fear aside.
Yeah.
To then know that you're probably going to screw something up, but as long as you work hard and you do your best. And the other thing too is, I think projecting that you know what you're doing.
Yes.
Because like when I went into this trial, my first trial I had, I was like, I don't know what I'm doing, but no one else is going to know that unless I let them know that. And so
Correct.
I just pretended like I had done this a million times.
Yeah.
Oddly, it worked.
Yeah. What is your approach when you're preparing for trial?
I'm one of those guys who has to know everything. And I think that process starts at the beginning of the case. And I don't, it's very rare that I'll just sort of like not be fully familiar with the case, like right out of the gate. I think over several years, you just end up knowing everything. I mean, I could just tell you, I could probably tell you the date that my med mal client had his leg amputated as I sit here right now. And that was a case that resolved 3 years ago. And it's just, I think that's just, it's not being afraid to roll your sleeves up from the beginning. And if you do that and you know the facts better than everybody else, you will always be more prepared. I think that's probably what served me the best.
Yeah. Do you like doing that, working on the cases from the very beginning? So I know some law firms, they have pre-litigation department, and then the case gets handed off from this lawyer to this person, to this person, to that person. Yeah.
So on a mass tort basis, we'll have cases that come in and I'll review the intakes, and I may not dive into them because they're not going to be trial cases or they may not have been picked yet. But once they get picked, it's a big enough thing that it's that, and that's nice luxury, right? Like if I was doing, maybe smaller cases, I may not have the luxury to dive into them as deep as I do, because a lot of them are big cases with bigger consequences. I have the time and we have the resources to put into that, and so that's a luxury, I guess you'd say, that I get to know everything and research everything, to the hilt, and know all the facts and take as many depositions as I think I need. And so I'd say I'm probably weaker as a result on being able to having to choose between what I need and don't need, because I've always been allowed to go and get what I need.
Right.
And then you find out afterwards you didn't need that,
Right.
So yeah.
Yeah. The mass tort litigation, I've seen some of this stuff, the Roblox stuff. Is that also considered, are those mass tort cases?
Yeah, I think so. Mass torts would be anything where there's a defendant, usually a corporation or government that has done something that one could argue is negligent, and that conduct has harmed lots of people. And so those video games, like the social media cases, they're not your typical I was sort of grew up in drug and device cases.
Yeah.
But we've got Roundup, and we've got talcum powder, and we've got social media, and we've got the video game addiction cases, and the Uber sexual assault cases, and they don't fit that typical mold, but they are in the sense that someone's doing something wrong and it's harming lots of people. They all fit into that bucket. Water contamination is another one, right? Like Camp Lejeune cases. So those are not drug and device, but they are similar in that respect. So yeah.
My family immigrated here from Cuba after Fidel Castro took over, and this government took everything from my family, and that attracted me to be a lawyer. Insurance companies can be like bullies, and they have a lot of resources behind them. Give us a call here at Hearst Limontes. We are protective of our clients because our clients matter and you matter. At Hearst Limontes, we're a firm that believes in people. We don't just talk about justice or fairness, we live it. The Indiana Fever are trailblazers. They inspire not only in how they play, but how they lead in our Indiana community. Being a father changes everything. Supporting the Fever is one way that I show my kids what it means to believe in fairness, to believe in respect and possibility. At Hearst Limontes, we believe in those same things. The Fever stand for resilience, grit, determination, and heart. They aren't just a basketball team. They're a symbol of what's possible when you refuse to give up. Their impact ripples far beyond the court, and you can see it in the energy, pride, and hope that they create in our city. Whether you're a young girl dreaming of playing in the WNBA or a kid in a small town dreaming of becoming a lawyer, you belong. This partnership is proof of that. At Hearst Limontes, we believe in standing up for those people that are overlooked. From court to court, Hearst Limontes is your winning team.
The the medical device cases, those are interesting. There's quite a few manufacturers here in Indiana, is that right?
Yeah, there's Biomets or Biomets here. There's Cook in Bloomington. Obviously, Eli Lilly's not really a device; they're more drug, but they're here as well. So yeah, there's a good number of them in Indiana.
And what's the statute on those?
Typically, statute of limitations in Indiana is 2 year with a discovery rule. So it's within 2 years of when you knew or should have known that
I see.
maybe the drug or device was contributing to your problem. And obviously, unlike I always tell people, I'm like, unlike a car accident, where like exactly the minute you're hurt and where it came from. With a drug or device, it's there's some. It's not quite so obvious, especially more with a drug. I'd say too, like some of these drugs, a cardiovascular event, right? Things that can happen to you even if you weren't on the drug, that can create some sort of latency in discovery. The device case is a little bit less so, but still to some degree. You have a metal on metal hip implant that causes metal poisoning, and you have odd symptoms from that, and you maybe don't know what they are. The bigger challenge in Indiana, I'd say, is the statute of repose, which is 10 years from first use.
Yeah.
So if you have a device or a drug and 10 years in a day, you have no case, you're toast. And that's a problem.
Oh, okay.
Yeah.
All right. And so then regardless of even the discovery, you still have to, let's say you discovered something after the fact, you had your knee replaced, but that you didn't notice it for 3 years, you still have your statute of repose issue.
Yeah. So if if your hip implant fails at 10 years in one day from implant, then you don't have and that's a substantive barrier. So you can't, and that's an interesting thing that I researched probably for a couple of weeks at one point. My career was, how can I beat this by filing somewhere else? And it's not easy.
Like in another jurisdiction?
Yeah, in another place.
So are you licensed outside of Indiana?
I am. I actually, I had a big hernia mesh litigation that I was convicted of in New Jersey. So I'm a New Jersey lawyer now, which is, was a little daunting and scary. Yeah. So far I'm still a New Jersey lawyer.
Yeah.
We'll see how useful it proves to be in the future. So.
Hey, you guys, I want to go back to the practice, Cohen and Malad. You guys don't just do PI work and mass torts. There have been some other, some appellate work that's come out of your office, and then some other litigation.
Yeah, so we've got a pretty robust practice area kind of slate.
Yeah.
And Gabe Hawkins is really, really great on the appellate side.
Yeah.
He's gotten some really incredible things accomplished, including keeping my first jury trial verdict intact.
Yes.
Which we could talk about at some point maybe. But
Yeah.
we've got a really good commercial and business litigation group led by my partner, Mike McBride, who is one of my oldest and dearest friends. We have a really good family law group that's led by Brian Zeller and Julie Andrews. We've got an amazing class action group, as I'm sure you know, that is led by Lynn Toops and Richard Chevitz and others, and obviously Erwin Levin. We've got medical malpractice, which is really a strong group in our firm. And so we've got a really nice, diverse practice group. Sexual abuse, sexual assault, those all kind of fit under the personal injury umbrella.
Yeah.
We do a lot of, if someone's been wronged, if they call us, we can probably figure out how to help them.
Have you worked on any of the sex assault abuse cases? They're tough.
I worked on one once. I may do some more in the near future. They're hard. I mean,
it's tough as a girl dad too. I mean, when you see that,
I have daughters that are the same age.
Daughters,
It makes me, this whole Epstein file thing makes me really want to. And the thing that I think is the hardest to sort of wrap your mind around is that I think this stuff happens way more than anybody thinks.
Exactly.
which is really scary.
It is.
Yeah.
Absolutely. You mentioned your first trial. Let's talk a little bit about that.
Yeah.
Yeah. So clearly the appellate practice group there saved that verdict. Yeah. So tell me a little bit about that. What happened?
Yeah. So you want to hear about the appellate part, or you want to hear
The case. Yeah.
Yeah. So the client was a truck driver. Was driving his truck through Gary, Indiana. Spent the night. Woke up with nausea and vomiting. Just didn't feel right. He went to the hospital. I guess he had some episodes like this before, where maybe his stomach lining was thin, and he'd occasionally get sick. And I'll tell you, I've had similar situations happen to me before, and so I can understand this. And he goes to the hospital. I think he was a little bit out of it, and his IV came out a couple times. And so the nurse decided that she was going to put the IV in his foot. And usually IVs go in your hand, the antecubital, which is in your elbow. Sometimes they can go on the wrist. Yeah, it's pretty uncommon that they go like on your lower part of your body, especially the foot, because it's pretty far from your heart. Yeah. And the vessels and the veins and things like that are small. Yeah. So she puts an IV in his foot, and instantly, ow, that really hurts. What are you doing? And she put it in, left it in, and I guess eventually a couple hours later they took it out. But he just would complain of this severe pain for about 24, 48 hours. Just kept getting worse. Couldn't put weight on his foot. They weren't really doing anything at the hospital. They're kind of like, this guy's, still complaining about this. And eventually he's on crutches. This is 3 days later. His nausea and vomiting is resolved. Now the new problem is the foot, right? So finally on Thursday, he got in on a Monday. Thursday, they discharged him. And he had to get on a bus to go back to his employer in Iowa to get his truck back. And so he goes in the bus, spends the weekend resting as they told him to. Next Monday goes to the hospital, and they're like, your foot's dead. Like,
wow.
They're like, you have a blockage in the arteries in your foot, and we can't do anything about it at this point.
Jesus.
We're going to have to amputate your leg.
Yeah.
So anyway, that was maybe too much detail, but
no. It's, it's important for people to hear that. Yeah.
There's a little bit of this, race ipsa loquitur, right? Which
right.
is, the thing speaks for itself. It's like,
yes.
You're not supposed to lose your leg just because you had an IV.
Right.
So that was a really interesting case. And, it lasted, I think we litigated that case for maybe 8 years.
Wow.
Hard bruising battle.
They were qualified providers?
Yep.
Were there any non-qualified?
There were not, no. It was 2 hospitalists, and there was 2 hospitalists and a nurse, and then the hospital.
Yeah.
All employees. So they were all qualified by being employees.
Yeah, I mean that's tough medical causation right there. Without did they do any testing or anything to show that it was the IV? Like how'd you prove that?
That was hard, right?
Yeah,
and it was the hard part was, do we need to articulate what the mechanism of action was? In other words, the IV went into this spot. Okay. Then this happened, and then that happened.
Correct.
And the question was, do we need to have a story for that? And ultimately, we decided, no, we don't. And ultimately, what the story was is you should be able to put an IV in somebody and not let them lose a limb.
You simplify it.
And, we know that he clotted up in his leg, and we know that's what caused him having an amputation. So that's kind of what we went with. But it was, it was a challenge to figure out how we were going to deal with that.
Yeah.
For sure.
And you said that went to verdict, right?
It did.
What was the result?
So I think we asked for $10 million. I'm trying to remember, $10,950,000.
Mm-hmm.
And they gave us $11 million.
Nice.
So they gave us a $50,000
little cherry on top.
Little bump. Yeah.
Yeah.
And I just, and I think, there's this mentality in my firm, which is, like it's caps, right? So like, why would you ask for so much? And it's like, because that's probably what his leg is worth.
Yeah.
Right. And it's probably worth more than that, to be honest with you. And I don't want them to think, why are these lawyers only asking for $1 million?
Yes.
The thing I used to do before that was I'd walk around, I'd go, and I have a couple friends that are, I'd say maybe more very conservative and maybe would, question, something like this. And I'd say, all right, well, how much money would I need to pay you right now? Right now, maybe it could be next week, whatever, for me to saw your leg off.
Yep.
How much money would it take? My answer is $0. There's no amount of money in the world that I would take to let you take my leg.
Nope.
Which means that it's worth probably way more than $10 million.
Yeah.
So, anyway, and then I thought that was a really like a reasonable way to go about it.
Yeah.
And I think at the end of the day, it ended up being like $500 a day, you know,
Yep.
for the rest of his life, which is not a lot.
Nothing crazy, right? For losing a leg.
Yeah.
Yes.
I mean, literally, the guy would wake up in the middle of the night to go to the bathroom, and it was like he had a choice: do I put this leg on, this prosthetic on, or do I crawl to the bathroom? And he
Yeah.
had to crawl to the bathroom every night to go to the bathroom.
Mhm.
I mean,
Yeah.
mind blowing. You know, he's
Right.
got phantom leg pain and
Yes.
all this
which
other
is
stuff.
a real
You know,
thing.
It's every moment of every day. It was on his mind,
Yeah.
and that's worth something.
Yeah, absolutely. So I mean, you see something like that, and then that's the same thing that I would say to these legislatures that are pushing this tort reform and want to put caps on damages. I would ask them the same thing. If I chopped your leg off or took your arm or took your hand, how much is that worth to you? You know, how much is that worth to you? Because I can tell you this, for me, you take my leg or my arm, $10 million, that's the tip of the iceberg right there.
Yeah.
That's just the beginning.
Yeah.
Yeah.
And you know, the thing is, that money's not going to make you feel good.
No.
It's not. Like, it's going to help you buy a good prosthetic. You know, you see those Olympians that run with those cool blade legs.
Right.
I guarantee you that doesn't feel good.
No.
You know, and so, you know, when you lose a limb, money doesn't do it. I mean, it really just can't. And, you know, it's different when you have a wage loss claim, right? Like, okay, yeah, that was money I would have made. Now I've got it. But most of the time, we're not putting people back where they were.
Right.
And money is not, it's not an adequate substitute for
Poor
putting
substitute.
them back.
Yeah. Yeah. I mean, I tell clients all the time, at the end of the day, I can get you money. It's a poor substitute, and it's apples to oranges. You know, I think that's why we can struggle sometimes with evaluating these cases when it comes time to sit down and try to get it resolved, you know, because we got to put a price tag on this, or at least help the client identify a price tag, right?
Yeah.
Meanwhile, their price tag on the other side is way lower than what we would recommend. And then you just try to find something, right?
Yeah.
For the client. So,
and I will say on that one, just to put a fine point on it, you know, that one got reduced.
it
It
did.
was under the old cap, 1.25 million.
Yeah.
So, you know, he didn't get 11 million.
Mhm.
He didn't get $1 million. I mean,
Yeah.
there's, you know, when you take a case through trial and appeal, it costs hundreds of thousands of dollars to do that. You know, he did not get
No.
anywhere. He did not get even probably, he got less than 10% of maybe what he
Yeah.
should have gotten, and maybe less than that
Yeah.
probably. So it's one of those things where it's like, it's super bittersweet, right? Like you
Right.
do everything turns out right. You win the case for the client, you get a verdict and all that. But then there's just this sort of like archaic like law on the books that just hacks it up. And you know, that's a case of the jury said, yeah, you were liable, and here's what his damages are.
Yeah.
And to me, that's the problem. And I'll never stop saying this, but that's a violation of the right to a trial by jury. In my
Correct. It's a constitutional violation.
Absolutely.
Because they have already defined what they think the value of that claim is. And just because the legislature, who has insurance companies in their pockets, doesn't agree, and they put these caps on it. I mean, that your case right there is a perfect example of why caps are wrong. Because the jury decided that his leg was worth $11 million and he should get that from this company, you know. Meanwhile, they reduce it on the other end. Nobody ever hears about that. You don't hear the legislator who's screaming about tort reform talk about how your $11 million verdict was reduced down to the cap.
No,
They don't talk about that, you
Right.
know. They just talk about the big number.
Well, I'll tell you
So-
this too. The jury, some of the jurors came up to us afterwards. They deliberated for 3.5 hours. I think there was 3 or 4 of them. And I can tell you with absolute confidence, having talked to them, they didn't spend much time deciding whether there was a statute of care violation or standard of care, excuse me.
Yeah.
The primary focus that they had was, what is this worth? So they're spending hours, you know, running through calculations, trying to figure these things out. And at the end of the day, that was all for naught because
Right.
it didn't matter.
Right.
And that's the part that's unfortunate. And again, to your point, I didn't have the heart to tell them at that time in the parking lot that, he was not going to get that.
Yeah.
I just didn't have the heart because they were so proud of what they'd done. But that was the hard part for me, honestly, stomach.
Yeah. And the fact that they were so thoughtful about it and sat down and really thought about what it's worth should be further evidence that we don't need caps on damages.
Right.
The juries are thinking about it. They're putting all of the facts that are in front of them and putting it, applying the law and finding a fair amount. So again, it's just more evidence that these caps, this tort reform is not good for anyone.
No, I agree.
Yeah.
I think it really grossly sort of misunderstands the fact that juries are responsible for deciding not only liability, but also damages, right?
Right.
That's liability is one element and damages is another. And effectively we're saying, you can decide this, but it means nothing. We're going to let somebody else decide this. Somebody who's not even looking at the case. It's just this hard, fast, cap that, I mean, a baby dies. I mean, that's worth more than the cap. I mean,
Yes.
so, to me, it's just this. And the thing is, the cap, this is the other part that makes my blood boil. The cap only applies to a case that has merit and ends up resulting in a jury verdict for the plaintiff. It doesn't apply before that.
No.
It doesn't affect it.
No.
So it only affects meritorious cases.
Yeah.
Yeah. And that's what's tough.
And to get there, and we've had people on the show talk about med mal, to get there, you said 8 years. To have a med mal case like that, you've got to essentially file 2 lawsuits. You file your Department of Insurance complaint, and then the complaint after that in the county court.
And we had a 3-0 panel for the defendant on this one.
Yeah.
So all 3 doctors said there was no standing order violation. So it was,
And you got $11 million.
It was a big flyer. It was a big swing. And look, sometimes but that's one of those cases where I was talking about before, where I get to go in and just really just like dive into it and work it. And I maybe overworked that one because I was afraid of, on some level,
got a big verdict though. Yeah.
You're afraid of family for this person,
Of course.
So,
Yeah.
there's a lot of pressure there.
There is. Yeah.
And somebody who's lost their leg is, that's a real struggle.
Yeah.
And you end up taking it really personally. And I did. And that made the win that much sweeter, I think.
Well, exactly. Yeah. So, well, let's talk about the future.
Yeah.
What's next? What's you're supposed to be at the AEJ conference right now, aren't you?
Yeah. Sometimes
It's hard with the kids.
Yeah, it's hard with the kids. And, it's hard with, my workload is shifting a little bit right now. We're sort of re-strategizing about how we're doing mass torts and some other things I'm going to try to pick up on. And so I just, for right now, I'm going to keep my foot on the gas pedal here. Definitely miss going out there. I mean, it's such a great organization.
Yeah.
There's so many good lawyers. And I know a couple of them that are out there right now I would love to be having a drink with. But this is a good second place.
Right.
Yeah.
Right. If any of our listeners want to get a hold of you, how can they do that?
A couple ways. They can, I guess, call me at the office.
Yeah.
It's I don't know if you want numbers, but
Yeah. Go ahead.
317-636-6481. Ask for Ned.
Mm-hmm.
I will say I like to see myself as a lawyer matchmaker. So if it's something where I don't do it, I'll probably regret this, but I love finding people, the right person, because the right person isn't always me.
Yep.
And, I think instead of just calling somebody that's on a billboard or that's on TV, like, I think you've seen those ads. It's like, they're actually kind of funny. It's like, hire a lawyer. Don't hire a lawyer because of their billboard ad or their bus ad. And usually it's someone's bus ad.
Yeah.
But it's true. You shouldn't. I mean, you should hire somebody because you think they're going to do the right job for you. And it's hard to evaluate that when you're not a lawyer. So anyway, I take pride in trying to find people, other lawyers that they can use if I'm not the right solution.
Yeah.
So
Absolutely. And similar mindset here, we always say, if we can't help you, we'll find you someone that can.
Yeah.
Yeah. Because it helps us all. It helps all the lawyers. It shows that we are a community together, and also shows that the general public that, lawyers were not out just for ourselves. We want to make sure that they wind up in the right place. Yeah, that's going to best take care of their case or issue, whatever it might be. So
To me, the big rule of thumb is if you would trust the person to watch your kid for 2 hours, then then that means that they are probably worthy of being home.
Yeah.
And if you wouldn't, you think about that.
you know what? Sometimes I wonder. I'm like, do I want to do this to them? Do I want to make them watch my kid? Can they survive?
Right.
2 hours with mine. So, well, Ned, thank you so much for coming in. I really appreciate it. Thank you so much for being on the show.
I'm happy to be here, and I think what you're doing here is cool, and
Thanks,
I
man.
appreciate that you invited me on.
Yeah, no worries. We'll do a bourbon episode here sometime.
Amen.
Coming up. So, thank you, everyone. Thank you for tuning in to another episode of Circle City Conversations. Make sure you subscribe so you don't miss out on any future conversations.